Well, I'd like to welcome everybody. It's March, it's spring. What do you think of? You think of March Madness and Public Interest Week here at Penn Law, which is really a wonderful, wonderful tradition in which this week we have the SPARE Symposium, we have public interest alumni who are coming back to the law school, we have a whole variety of activities, but I have to say something that is truly special and part of this is the Honorary Fellow, which has been a tradition here at Penn Law School really going back to the 1960s. I was going to start with a quiz asking people if they know who the first Honorary Fellow was at Penn Law School in the 1960s. It was, and there's a portrait down, a small little plaque downstairs. You will see an extraordinarily young-looking Ralph Nader, who was our first Honorary Fellow. And we have had plaques of a variety of the different Honorary Fellows over the years, and they are truly a who's who of public interest and public service. Now, it used to be that the Honorary Fellow would receive a plaque at graduation, but we decided it made much more sense for the Penn Law community and for everyone involved to rather create a week of public interest activities and to have the Honorary Fellow come in and spend time in the institution and really talk about their career and what it means to start a public interest career. And so it really is a true pleasure and an honor to welcome, as this year's the 2011 Honorary Fellow, Joan Graff. She's somebody who has had, in almost every way, a path-breaking career. She's a nonprofit entrepreneur par excellence, and as somebody who is involved occasionally in raising funds, I really am awed by her ability to engineer and to really expand an organization. And she also is somebody who's been a mentor to really, literally hundreds of public interest people starting careers. So, how did it all begin? She graduated from Columbia Law School in 1967, which, it was a different era in public interest law and for women. I just asked our speaker how many women were a class at Columbia, and there were only 10 at that time. More importantly, in some ways, she probably couldn't have conceived of a public interest career at that time because it didn't exist. Literally, it was not something that anybody saw as an avenue that one could pursue with a law degree. So she started working in the general counsel's office at the EEOC, then later moved to San Francisco, and with 3 or 4 other people co-founded a couple years later the Equal Rights Advocates in San Francisco, which was truly path-breaking. It was one of the first women's rights organizations in the United States and really set a model at that time. She worked there for many of the years, and then in 1981, she became the director, the first female director of the Legal Aid and Employment Society in San Francisco. Now, to say that lawyers were at the door when she took over that organization is an understatement. It was near bankruptcy when she took over. It was described as in a sense, a ramshackle building, really incredible challenges for the organization. There were 4 lawyers and 4 support staff at that time. We actually did a little looking around and spoke to some people, and they described when she arrived that the place shone brightly when she walked in the door. The drab surroundings seemed to dazzle with her there. Spirits rose. Slowly and steadily, Joan steered the society out of immediate danger and set a course to make the society ground zero for public interest law. Today, she oversees a staff of 30 individuals, including 13 lawyers. It has 100 volunteers who work with the organization and more than 100 law students from San Francisco. And she raises to support this $4 million every year in this environment from the legal community, both in San Francisco, more nationally. It's an incredible story of somebody who has a vision and entrepreneurial spirit and passion for the organization. In terms of the legal work that they've undertaken, obviously they've over the years have expanded from general legal aid to a wider focus on employment law, assistance for the working poor, covering issues that include wage and hour violations, unemployment compensation, family and medical leave, public school access for disabled students, and a whole variety of cases on discrimination in every category: disability, parenthood, pregnancy, gender, sex, immigration status, language, sexual orientation. Every single major cutting-edge issue, in a sense, comes in the door. She's been involved in a number of landmark cases. Her center was responsible for the 1996 decision, which held that undocumented workers would have standing to bring retaliation claims against employers who report them to the INS. And then in 2001, the center won a case that rendered unlawful the state's practice of requiring job applicants to complete non-job-related medical questionnaires. There's one other quality that I want to point out about our honorary fellow this year, beyond really her passion for the organization and legal issues, is that if you talk to people at the center, one of the first things they comment on is her ability to lead a team of people that feels committed to and involved in the organization. She truly knows how to lead by bringing the group into the involvement and decision-making of the organization. One of her staff members said to us, Joan truly values people and the opinions of those she works with, collaborates with, and who work for her. When you're lucky enough to work at the center, you'll be included in important decisions. Joan will come to your door if you're a staff member to speak with you. She will call you if you're a board member, and she will ask you to reach out to others. You think you should be valuable in every discussion. She creates a truly inclusive and enjoyable workplace where the team can focus on the mission. So I think it's safe to say, not only in her ideals and the issues to which she's committed, she epitomizes the professionalism, the collegiality that we look for and we think represents Penn Law School. For these and so many other reasons, it really is a pleasure and an institutional delight to be able to introduce to you this year's, the 2011 Honorary Fellow, the Penn Law Honorary Fellow, Joan Messing Graff. Thank you.
I'm overwhelmed and think I should leave now while I'm ahead. I'm so very happy to be here. I'm so pleased that the school has this special week. And I'd like to thank the Dean for having me here, along with Tori and Arlene and everybody else who participated in having me attend this wonderful event. I'd like to talk to you a little bit about our organization, which I'm immensely proud of and feel that could serve as a model perhaps for other organizations that you all might want to found in the future. But first, I think maybe I'll introduce myself a little bit more and tell you that I was raised in New York in a family grounded in social values, which I think is partly where my passion for justice comes from. My father, in fact, was a lawyer and was one of the first members of the Lawyers Guild, and so our involvement in social issues goes back way far. And my mother, likewise, was very involved in issues like Amnesty International. My brother is a union side lawyer, and so there's a lot of activism in our family, within our profession. I attended the Cornell School of Industrial and Labor Relations and had as my dear friend Michael Wachter. And as you know, we have parted company in terms of the work that we do, but we've remained very close and compassionate friends. I then went to Columbia, as the dean said, and was one of few women, and it was quite a horrifying experience, including the fact that Justice Ginsburg was denied a job on the tenure track and was asked instead to be a writing instructor. So it gives you a sense of the climate of the times that we as women faced. Upon graduating law school, I had an opportunity to go one of two directions, either the EEOC or the NLRB. And somehow, by accident or foresight, I chose the EEOC and thus launched my career. As you all know, I started with the EEOC and then went west, as people say, go west, young woman, and co-founded Equal Rights Advocates in the early 70s. And it was an extremely thrilling and exciting and joyful time when women felt full of possibility and opportunity, and I was so pleased to be a part of that movement. It was not without its tensions. I wouldn't exactly say that women lawyers were embraced in the profession. There was such restrictions as having to wear skirts to court, that you were penalized if you wore pants. It took a long time to get rid of that particular requirement, but it was thrilling, and we made huge amounts of success in creating employment opportunities for women. Employment, again, was our major focus as the key door into opportunity. I then came to the Legal Aid Society Employment Law Center as the first executive director, who was a woman. At that point, the organization was 65 years old. And it was very interesting. Shortly after I arrived, we had a meeting with the then chair, and he came, and we had 3 women lawyers on staff, myself, one male lawyer, and a couple of other people. And he looked around and he said, "I'm surprised you're not an unattractive group of people." It's like, what, if you're in the nonprofit, you're not attractive? I mean, it was sort of really a rather startling admission on his part of the stereotypes of what we who do this kind of work must be like. Now to my organization. Oh, just to complete it, I have 2 wonderful children. I have a daughter who's a lawyer working in a public interest program dealing with issues of public health. And I have a son whose public interest bent is at public policy school and will go to Stanford Business School next year to pursue a public interest career with those sets of skills instead of legal skills. I'd like to talk to you a little bit about my organization. I'm so proud of it. We were founded in 1916 and will turn 95, and we have been in continuous operation since that time. We have 2 missions really. One is devoted to represent low-wage workers with the full range of problems that they face on the job, which are many, as you might imagine. In addition, we are committed to training law students in public interest practice and creating the next generation of public interest lawyers. And I'm very proud to say that we've been very successful at that, and are very happy to play a role in offering our skills and expertise to students who would like to do the work that we do. Our clients, as you know, are poor. They suffer from the range of problems from non-payment of wages, to discrimination, to harassment, to denial of benefits and leaves. And they have been on the front lines of the crisis that the recession has brought, and the amount of clients that have come to seek our help has just increased exponentially. It's important that our clients are involved in the work that we do. We value very much being community-based. And one of the things that I feel particularly pleased about is that we're one of these rare organizations and have been able to marry direct services with impact litigation. And you may ask why that's sort of a unique situation, and that is because direct services and impact litigation require very different skill sets and often attract very different kind of people who do that work. Historically, people that went into direct services were were very grassroots, very down with the people, very enforcement-oriented, helping one client at a time. I remember when I first came out to San Francisco, there was a value that was strongly urged that if you were in direct services, you went and lived in the communities with your clients as your clients lived. And there were lawyers, indeed, who did that. On the other hand, people who are public interest lawyers consider themselves lawyers that do impact litigation and create change through law reform work. The views across the bar of those two were very, very tense. I mean, impact lawyers viewed direct services lawyers as being politically correct, constantly governed by political correctness, whereas public interest lawyers were viewed by direct services lawyers as being elitist, as being arrogant, as defining what the agenda should be, and ignoring the client communities and what their priorities were. And this was a very lively and intense problem. Our organization had some of that internally for a while and got over it. We worked through it and reached a very successful model of running clinics where we do direct services, helping poor people immediately with their problems, along with impact litigation. And happily, the culture of both of these sides of the office are completely merged, and I can admit with some embarrassment that wasn't always the case. I mean, what was playing on in the community at large came into our organization, and the struggle of what's more important and what's more real and what's more connected and what's of greater value was a constant source of conversation, which we ultimately resolved and have a very thriving practice that integrates them both. And the other thing that works well is that our direct services program, which we hold 4 nightly clinics around the Bay Area, very much feeds our litigation and feeds what we do and determines our priorities. And so I can actually say that we are not litigating from on high and coming down into the community and saying, we know what's best for you, follow our lead, and we will bring a lawsuit and you will be happy. We rely instead very much on what the client communities want. I'd like to give you an example of one of our cases that came through the clinic and ended up in litigation. And that is a woman, Maria Escobida, who was from Guatemala and worked for Foster Farms, who, as you know, produces chickens for consumption, for over 20 years as a laborer. She had a perfect record. She was a loyal employee, and she raised 3 children at $9.70 an hour and sent money home to her family in Guatemala to help support them. Her father in Guatemala became ill with prostate cancer, and she went to her boss and asked for permission to have family leave to go and visit him because he was gravely ill. She was granted the leave, went down to Guatemala, spent some time, returned, and upon her return was promptly fired, illegally, unlawfully, without any reason whatsoever. She then was unemployed and living in the valley, which is very hard to get work outside of agriculture, ended up doing occasional work as an agricultural worker and really struggling and suffering. We're taking her case, we took her case and we're taking her case to trial. And one of the things that interests me about her situation is, why are we going to trial? I mean, excuse me, but why is this being litigated? Why aren't we settling this case and getting our client a job? The answer is, I don't know. I mean, it's not through any lack of our efforts to try to settle this case. For whatever reason, the defendant is absolutely resolved in its commitment to oppose this case. And I take from this real concern about how litigation helps our clients, but how it's often perverted for reasons that don't relate to really the issues at hand. And I don't have an answer as to why this is being incredibly vigorously defended. but I can tell you that it is. One interesting thing is that we needed an expert to talk about medical care in Guatemala because the defendants were raising the issue that indeed her father did not have prostate cancer and that she was making all of this up. And so we found a doctor with expertise who actually was raised in Guatemala, and he is our expert. Well, lo and behold, when it came for us to depose their expert, it turned out to be a doctor from Guatemala who was from the same village as the doctor that is our expert. Which I think is just a sort of funny commentary on how these cases are litigated in some way, an eye for an eye. They didn't really need a Guatemalan doctor. I mean, that wasn't really of the essence to their case, but that's what they thought would be useful. So, on the other hand, you know, as I mentioned, our direct services very much feeds the litigation that we do, and I'd like to talk to you about another case, which was really a groundbreaking case that we brought on behalf of black firefighters who were systemically excluded from positions in the San Francisco Fire Department. Now, you know that fire departments have been historically closed doors to people of color and women. They are jobs that are generally handed down through nepotism. They are extremely desirable because they're very high paid with a very early and very full retirement. And there's a culture around firehouses where people live together. And so there's a clubbiness that grows up around being a firefighter that's rather unique. We brought a case. It took us 15 years to resolve it. We worked in coalition with organizations that represented Latinos, Asian Americans, and women firefighters. And ultimately, under the leadership of a very fine judge, district judge in our court, we reached a settlement that then required years and years of monitoring. The level of resistance was extraordinary. The good news is that one of our plaintiffs became the first African-American fire chief, followed by the first woman fire chief. So you can see that when you break down boundaries, it may not take a long time to really have immense successes. However, on the other hand, we're still getting calls from firefighters, particularly African-American firefighters, complaining about constant harassment, undermining on the job, trucks that are being fixed in such a way as to make it impossible to do their jobs. And it continues to be a hostile work environment. And so in some ways there's successes because the leadership has changed, and that's really important in a community, to look to leaders and see people of their own color or women to know that it's possible for them to do this work. On the other hand, the day-to-day lives of many of these firefighters continue to be very difficult and very hard. Now, we may ask why we do employment law. And I have to say that for me and for those I work with, employment law is the gateway to people's lives. It is people's lives. We live in an economy that's wage-based, obviously, and for most of us, we rely on the income from the jobs that we have. But interestingly, what we've learned in our work is that work provides self-worth, a sense of value, a sense of identity, and a sense of purpose. And it doesn't matter what your job is. I mean, I see that among the people I work with, and I see it among our clients. People just are very, very involved with their work and take a lot from it apart from their paycheck, which is why fairness and equality on the job is extremely important. And you know that studies show that Americans are spending more and more and more of their time at work. And as a result, a lot of people's lives are being played out at work. It used to be that people went to churches for support or community centers for support. But now, much of life occurs in the workplace. I mean, we have showers, we have, we recognize deaths in people's families, we recognize birthdays. It's a cultural phenomenon that is kind of extraordinary, and work also provides the microcosm for the society at large in terms of diversity. It's a place where people must come together, must work together regardless of their prejudices, and begins to break down those biases. The other thing about work is that it's very supportive of people, and if the community is strong and present, it makes a real difference in times of crisis for people. We had a colleague who came to us very poor. He was referred to us by a welfare to work program. He'd been working in a secondhand store and came and kind of did odd jobs at our office. You know, he did some filing and he did answering the phones, and he was HIV positive. He worked with us for 10 years, living with AIDS. By the time he came to our office, he was in his 50s. And it was really remarkable because despite the illnesses, despite his ups and downs physically, despite the pain that he was under, despite the tremendous influence of the medications that he had to take, he showed up at work every single day, and did what he could. Because work and being with people in that environment was so critical to his mental and emotional health that you know, hell or high water, he showed up at work until he could no more. And then one of us accompanied him to Arizona to a hospice that he chose to spend his last months in, and he died 2 months later. And so I tell you this story because it's a sort of human face of what the workplace is, and how meaningful it is to people in all parts of their lives. I can tell you the story of another client we represented, whose name was Daniel, who was a mailroom clerk who had worked for more than 20 years for Sumitomo Bank. He had a developmental disability which limited the functions that he could do, but he was very adept at doing the job he was told to do. Well, what happened was the bank outsourced the functions that he was performing. The company that came in that took on the job and fired Daniel after 20 years of work because they just didn't find him responsive enough. They just didn't want to understand his developmental disability, that yes, he was a little slow, but he certainly could do the job and obviously had done it for 20 years. Daniel was devastated. For him, his job was himself. It showed that he was a meaningful, contributing member of the community. And for people with disabilities, this is a very, very important issue, of course, as it is for all of us. And he was devastated. We brought the case and we obtained a very good settlement for him. But again, it was a hard-fought case that went up to the Ninth Circuit and back. And again, I have to ask why in Maria's case, why in Daniel's case, we had to litigate for years to get people justice. It's not at all clear why why Maria's case hasn't settled, why Daniel's case didn't settle. I don't know. I just leave you with the question. I don't know the answer as to why. The vulnerabilities of our clients have been on full display during this recession, as I'm sure many of you know. They have been particularly hard hit because they occupy very low-level jobs and are viewed as dispensable, and when budgets get tight, they often just disappear. I'm sure some of you know the statistics that the top earning 20% of Americans, those making over 100,000, receive 49.4% of income generated in the United States, and the bottom 20% receive 3.4%. And the latest numbers say that more than 14% of Americans are living below the poverty line, which is shocking in our country, where we tend to think of ourselves as ahead of the game on that. And some have put the numbers as high as 20%, because of course a lot of immigrant workers are invisible and don't appear in any of the census that are done. Also, it's interesting to know that even with those numbers, they may be underestimating it because standards for poverty have not been reevaluated for many years. And so clearly what was poor 5 years ago is not in any comparison to what is poor today. And so we find ourselves not being able to help people because they don't meet the guidelines, although they're supporting a family of 4 on $20,000, which by anyone's definition living in an urban area would constitute poverty. Of course, there have been additional instabilities that have affected our clients, like the outsourcing of jobs, such as Daniel's situation, the increased classification of workers as independent contractors. This occurs particularly among people such as janitors, where they're sent off and are not paid an hourly wage and have no benefits, no health insurance, and indeed are being very tightly run by a company that's telling them exactly where to go, exactly how to clean, exactly how much time to spend, but they're nonetheless characterized as independent contractors, and so they're denied all the values that being a full-time employee affords. So all of this has added up to record job losses, as you know, and as a result, our work has just spiked, although sadly the revenue to have more resources to meet the increased need has not spiked in the same way. Who are these workers that we represent? The people who call us are pregnant women, single mothers, disabled persons, both mental and physical disabilities, people of color, undocumented workers, immigrants, domestic violence survivors, workers with limited English proficiency, and members of the LGBT community. And we find them working in many different kinds of jobs that are essential to the lives of many of us, such as childcare providers, gardeners, laborers, janitors, attendants to people who are elderly or disabled, domestic workers. They work in agriculture, warehouses, big box stores, hospitals, retail, food processing plants, laundromats, manufacturing, nursing homes. So you've seen these people all about as you've gone about your lives, but in many respects, I feel that these workers are invisible. I think that we don't have any appreciation or understanding of their lives. You know, they come, they do their jobs, they disappear. We don't have relationships, perhaps language is a problem. But I think the key issue in terms of employers is that they're considered fungible. They have no face, they have no family, they have no life, they're not seen as real people. You know, they're here today, gone tomorrow, get someone else, here today, gone tomorrow. And it's very tragic and extremely sad as we assist our clients to see their pain and their lack of dignity at being treated as if they're nothing, which sometimes happens. Often happens. I think we have a client named Mr. Kwang, who came to this country and got his very first job, he did not speak English, in a laundromat. The employer had him work for 2 weeks for free without pay to try him out, to see if he could do the job of folding laundry. After that, he paid him $8 an hour for 7 hours a day, which is below the San Francisco minimum wage, and for 6 days a week, did not pay him any overtime, although he required overtime, and he required him to work on Saturdays and did not pay him. And this, by this employer, was just A-okay. This was an immigrant, whatever, you know, he had to take the job, he needed the job, he didn't understand his legal rights. And so we took on his case and we secured a settlement. A sidebar to this, in many of these cases, we secure a settlement, but sometimes it's a Pyrrhic victory because a lot of low-wage workers work for employers that don't have a lot of money. And as a result, when we then seek to collect on the damage awards that our clients receive, lo and behold, there's no money. And so it's extremely frustrating to have to deliver to clients a sort of moral victory of, you're right, you should have gotten this, but we're really sorry, the company either doesn't have the money, or a lot of companies declare bankruptcy when they're threatened with a judgment. And so it makes it very hard to deliver complete justice to the workers we represent. And the other thing that I want to comment now is that you may have heard me reference settlements that we've secured for these clients. And the reason why I only say that is because nowadays in employment discrimination and employment law in general, settlements are completely confidential. You are not allowed to talk about the terms of the settlement whatsoever. It's a clampdown that employers and defendants have placed on the plaintiff's bar. I think they view it as a means of not encouraging other employees to make baseless claims. We view it as a way of protecting their reputation in the community and not wanting media to expose their wrongdoing. So it's kind of frustrating to come and tell you a long story and then not be able to tell you the happy ending. So suffice it to say, if I say we settled, it was somewhat of a happy ending. Another case that we represented, which kind of illustrates some of these issues, is we represented a group of assembly line workers who lived in Fresno. And they worked at a plant putting together tiny little sprinkling things for sprinkler systems, you know, that people use on lawns. They were all monolingual. They were Latino and Southeast Asian, and they had done this work for up to 20 years. I don't know, 20 years seems to be a theme here, but it just seems that's the case with these cases I'm talking with you about. Anyway, the company is bought by a new owner, and the new owner doesn't want these workers and decides that he is going to give them an English proficiency test as a requirement for continuing employment. Well, obviously, every one of these people failed the test because none of them spoke English. That was a foregone conclusion. And as a result, they were all fired. We have been litigating this case for a decade. In the course of it, we made a very important law about the right of an employer to depose a worker about his or her immigration status. And we got a wonderful ruling from the Ninth Circuit that said that that is not permissible. And that ruling has been cited by 80 federal court decisions and hundreds of other legal authorities. So here's a case where we took it on for this one reason, which is to get justice for these workers, and we end up in the Ninth Circuit on a very ancillary but very critical issue for undocumented workers, which is the issue of the discovery of their status. And so we brought the case to trial in Fresno, which is a very conservative community, and needless to say, sadly, we lost. The jury found against us. We went to the Ninth Circuit because we argued that there was an exclusion of people of color from the jury, and the Ninth Circuit found in our way, and the defendants took it up on cert to the Supreme Court, which happily was denied. And now, 10 years later, we're remanded to the district court for another trial. 10 years later. The clients have been wonderful. They've been able to hang together, which is quite remarkable after given the life of this case, and have stuck together. The interesting thing about this case that I ask again is, why is it taking 10 years, 20 years to resolve these claims? These are 23 poor women, and what is this about? In this case, I believe it's that the new owner of this company is a libertarian, and his view is no one is going to tell me how to run my business, and I'm going to litigate this case till the bitter end as a way of showing you my view that you don't mess with my business. And we're going to litigate it to the bitter end too, and hopefully we're going to prevail on round two. But again, it's another, to my sense of miscarriage of justice. I mean, this case should have been settled. It should not have been worth millions and millions of dollars in attorney time to litigate. And these people deserve their rights and deserve to get on with their lives, and they're not going to have that opportunity to do so very soon. I want to talk to you about another case that I'm very proud about that our office just completed, and it has a funny twist, which I'll share with you. We represented a 70-year-old Spanish-speaking woman housekeeper who worked for a family in Hillsborough, which is a suburb of San Francisco that is very, very affluent. She was paid from $3 to $4 an hour, working 14-hour days, 6 days a week without any breaks, no overtime pay, no vacation pay, no sick leave, and a hostile environment. The couple she worked for owned this home, which was 10,000 square feet, plus a pool house, and she also was responsible for their daughter. This is a 71-year-old woman being paid $3 to $4 an hour. Now, she was a domestic worker, and domestic workers have a particularly hard time asserting their legal rights because there's not a community around them. They're very, very isolated. In this community of Hillsborough, houses are literally miles apart. They sit on tops of hills. They're like McMansions. And so, you know, they don't have any sense of support or community from people in like situations. And she had also developed a very strong attachment to the little girl that she was caring for, which makes asserting a claim very difficult because you have almost a familial relationship with the family in this way, and it's painful to sort of come forward and make a claim. But despite that, Vilma came forward, she found us, she made a claim, and we settled her case, I can say this because they forgot to include confidentiality, for $45,000, which for her was a huge amount of money. What was interesting about this case is there was a group organizing around domestic worker issues, and they decided to hold a very respectful march through Hillsborough to sort of communicate with other domestic workers what was going on and to educate them about these issues. And it was quite remarkable to see all over our newspapers pictures of these very, very lovely people carrying these big signs, marching through these McMansions in Hillsborough, and very effective. But this is what's interesting, and you wonder whether bad people always do bad things. So the wife of this couple that owned this house in Hillsborough turned out to have been accused of insider trading and passing on information to the CEO of Galleon. Now, you may know that Galleon is now the CEO is now in trial in New York. So we kind of felt just desserts, I mean, we got her, we got even with them by getting, Vilma what she was entitled to, and, justice got even with them because they caught her in this illegal and self-aggrandizing work, and no wonder how they could afford a 10,000 square foot house in Hillsborough. And so we felt very, very pleased all around with the result of that. Also, to show how clients grow during the course of being in a case, Vilma stepped forward and became very active in the National Domestic Workers Alliance, which is an effort nationally to create rights for domestic workers in the workplace. And indeed, we're working on legislation to get domestic workers basic rights like sick leave, workers' compensation, and overtime pay, wage and hour protections. And so that was a very good case with a happy ending. When I first came to the society, I want to give you a sense of the sort of the way the work of the office has expanded. We were doing traditional Title VII cases. That was in the 70s, shortly after Title VII was enacted, and that's where the action was. And we were very involved in doing big impact class action litigation. And an example of that kind of case, though, which sadly occurred over the last decade, was a suit we brought in Mississippi. We were contacted by a group of African-American employees working at a facility owned by Northrop Grumman. And to say that it was a kind of throwback to the 1950s is maybe even an understatement. The workplace was replete with nooses. replete with KKK graffiti with racial epithets. And there were no promotions of African Americans. The way it went was an African American in a position would train a white worker who would then be promoted to be the supervisor of the African American who trained them. We brought a lawsuit to challenge these activities in Mississippi, a very inhospitable environment, even though it was federal court. And you would think federal court would be a little bit more amenable to justice, but it wasn't. And we had a very, very difficult time there, very difficult time, and ended up settling the case. I am completely unable to talk about the settlement. Confidentiality with a capital letters was imposed on this settlement, but suffice it to say that we addressed the issues of equal opportunity and promotions and training, and addressed the issues of the harassment that was going on that workplace. It was quite a searing experience for my staff. Nearly everybody was involved in this litigation because it was just so huge, and quite traumatic and quite moving. A lot of the staff went down to Mississippi because we needed to be there for weeks at a time to do depositions, and learned a lot from that case. But as you know, employment law is also ever-changing. And that's the joy and wonder to me of practicing in the field of employment law. For example, in the 1980s, we expanded the work that we do to include disability rights, pregnancy discrimination, HIV/AIDS, wage and hour, unemployment, equal pay, harassment, drug testing, privacy, and plant closings. And this was quite a big deal because employment law had to date been really defined as a civil right that was limited to discrimination. And we felt that employment generally was a civil right, and it needed to embrace all the rights that people have. And we began to go to state court because federal courts during that period started to become very conservative. HIV/AIDS was particularly close to home for our organization. We had a colleague in the early 1980s, Felix Velarde Munoz, who contracted HIV/AIDS, and it was shortly after I arrived, and he was sick, but there was no name for it, and he didn't know what it was, and we were all very frightened and very concerned for him because he wasn't being diagnosed, and then at some point, he understood that it had to do with HIV/AIDS and came to me one day crying and said, I'm going to have to leave and take a job at the state bar because it's so important that our organization have the resources to do our work, and I'm not going to be able to work for very long. And so I am going to leave, which he did. And he died shortly thereafter. There's a famous book called And the Band Plays On by Randy Shields, and Felix is one of the early victims of HIV/AIDS that is written about in that book. So our organization kind of grew organically to be committed to addressing that issue in the way we could, and what we did was bring the first case that established HIV/AIDS as a physical handicap under our state fair employment and housing laws. And then we filed a significant amicus brief with the Supreme Court to secure the same ruling under the Americans with Disabilities Act. So I think I would count that as one of our most important decisions. By the 1990s, we then became involved in the Family Medical Leave Act and the state equivalent, in language and access discrimination, English-only rules, rights of immigrants and undocumented workers, affirmative action battles, which we lost, continuing to work in misclassifications, economic development, looking at first source hiring, where if there are projects in poor areas, you can arrange to get preferential treatment for residents of those areas so that they're able to become employed. And employment issues affecting domestic violence and sexual assault survivors. We recently decided to represent a woman, Irene Borromeo, who worked at a 99-cent store, and she was diagnosed with a medical condition that required immediate treatment, and she asked for family medical leave. Her boss said no. She asked again. Her boss said no. And all this time, she was being harassed by a man with whom she was involved in an abusive relationship. He'd show up at work, he'd call her there, he'd harass her, he wouldn't let her be at the store. And finally, she asked for time off from her employer to be safe from this abuser, because she was terrified that one day he'd just come and really, really harm her while she was at work. And she was fired by her employer because she brought too many of her personal problems to work. So we are now representing her in that case, a very painful situation, because you know that domestic violence survivors need more than anything an independent income in order to leave an abusive relationship. And if they don't have that, they can't. They're stuck financially. And so what the employer did was to empower the abuser by disempowering Irene from being able to walk away from the relationship. Since 2000, we continue to see emerging civil rights issues. We became involved in transgender rights. We did work on equal benefits for gay and lesbian workers. And we had a very important seminal case representing a transgender woman who worked at a very major retail store. And she was in her transition from male to female, suffered incredible harassment on the job, touching, photographs, rude comments. They wouldn't let her use bathrooms. And she was told that when she started dressing as a woman, that she was creating moral problems on the job. The store even required her to wear a name tag with her male name on the name tag, because they would not recognize her as transitioning to female. She came to us, we represented her, and we got a very good settlement. I can't tell you what it was, but it was very, very good. Nowadays, we're really excited because we see the possibility, maybe, of the feds passing an anti-discrimination law based on sexual orientation, and we're ready to go to take that on. We are also looking at getting involved. I don't know if many of you know this, but San Francisco was selected for the next America Cup races, and so there'll be a lot of construction, which is the good news for the city. Therefore, there's possibly a lot of jobs, and so we're going to try to get involved in securing jobs for low-wage workers on this through first source hiring. The other thing we've been doing is trying to extend the requirement for sick leave. We passed a local ordinance that made sick leave mandatory for all employees, and we're now working on a state version that would make sick leave a requirement for workers in California. I'm going on. Is this too late? I didn't realize it's 6 o'clock already. Wow. Shall I finish? Shall I stop? You sure? Huh? Okay, I'll make 2 quick remarks, and then I'll throw away the rest of what I wanted to say. I'm so happy to be here. I could just kind of talk with you for a long time. The only thing I wanted to add is we view employment law as increasingly elastic and looking at what matters to people to be able to work. And so we've become involved with transportation issues and education access issues. We represented actually our current Skadden Fellow, who has a congenital mobility disability, who needed a bus to get to work from Berkeley to our offices in the city, and the buses just would never stop for her. They claimed that they didn't know how to work the system, that it was broken. She'd sit in the rain in her wheelchair, and bus after bus would go by. And it was not only horrifying and upsetting to her work life, but it was an essential indignity for her to suffer this. And so We filed a lawsuit. This time we got co-counsel from Latham and Watkins because it was not an employment case, and got her a successful settlement. And lastly, we've done some work in educational access to state colleges, university, and public schools for disabled children. Both of these issues we view as roadways to employment. Disabled people suffer great numbers of unemployment because they were not able to get adequate educations, and because they can't do laboring jobs. They can't do the kinds of jobs that don't require education. We took that on and had some real successes in that area as well. And now I'll stop.
Joan, I'm not subject to a confidentiality agreement, so that was really wonderful. And let me say, obviously, I think anybody who's listened to your career and you talking about it understands why you've been such a success, and why, you know, your passion both for the development of law and your clients. But let me point out one thing that I think everybody picked up from that talk is your involvement with the lives of every single individual who you represented, and the way you frame what a difference this made in their lives. So I know everybody here is extremely impressed, but I do want to open it up for questions, and I'm going to take the first question, and then I'll open it up. I get the first. But so you have this connection, obviously, with the clients who come in the door, and people come in the door and you represent them. But then you've got this other hat, which is impact litigation.
Right.
How do you decide how you allocate your resources, your limited resources, and how do you decide what type of impact litigation you're looking for down the line? You talked about one case where in the Firefighters, you were really looking for a client coming down the door, but how do you make the decision about what areas you develop over time and how you allocate expenses?
That's done collectively in the organization. We have 4 program areas with 4 extremely charismatic and talented leaders, and they all, one is gender, one is disability, one is immigration, national origin, and the other is race. And they all are very up to date on current developments in the law and tend to define their programs and their direction and what are the important impact and enforcement cases that they feel are necessary in their field. We don't go out and look for clients. That used to be done years ago when public interest law was first founded. You know, you go to the community, you say, you know, wanted, we have this case, please come to us because we'd like to bring it on your behalf and deliver justice to you. And we quickly learned that that was not useful because if the community wasn't ready to receive the results of the litigation, it was worthless. You know, you really want the community to want the case and want to live with the outcome and enforce it and implement it and monitor it. Otherwise, it's meaningless. In terms of direct services and litigation, it's just a happy marriage. I mean, we have probably 4 of our staff, 5 of our staff people are in direct services, and the rest are in litigation. I don't know. That's how we do it, I guess. That's how we do it.
Questions? Michael?
I wonder if you could talk some about equal rights advocates, which is historically a very well-known firm in terms of the work that it did.
Sure, but I think people have to go, so I'll be brief. Equal Rights Advocates was one of the first 2 nonprofit women's rights law firms in the country. It was at the cusp of the women's rights movement. It led the development of feminist legal theory. It was an incredibly exciting and challenging time. On a personal level, it was a little hard for me because at that time I had just become a single mom. I had a daughter and was divorced. And the first wave of feminism in the early 70s completely ignored family. It just did not exist. And And so for me, it was very difficult to marry my commitment to women's rights as defined at the time by the movement and my real life, which is, you know, trying to take care of my child. And so, like, every day after work, the group would go to the local bar and drink scotch, and I would go home to get my daughter, who was with a high school student, because there was no such thing as childcare in those years. So, so I kind of lived the second generation of feminism, valuing very much the importance of recognizing women for being women and caretakers and extending that to men as well. But it was a very, very interesting time to do this kind of groundbreaking work. My work was basically devoted to low-wage women workers. I wanted to create employment opportunities for women so that they could have trades like carpentry and plumbing, or be on industrial production lines, so that they would earn a decent income. And so that was my area of focus while I was at Equal Rights Advocates for a long time. Well, I think to the extent civil rights laws involve money, there's always the issue of collecting the money. I think that injunctive relief is a lot easier. We often are involved in monitoring, which is almost necessary in many cases to ensure that what is on paper gets delivered to the workplace. But I think money is a key issue, and it's, you know, it's a struggle. We sometimes do a financial analysis or try to do some research to see if a particular defendant can afford a judgment, because if we have thousands of people asking for our help, at some point it makes sense to use that as a litmus test of what cases to take, because we can't do them all. And if we're going to spend a lot of resources and then find a defendant that doesn't have any money and we can't really deliver the remedy, we've become a little bit more wise about the need to do that. It's kind of sad, you know, but we feel that's something that we now have to do. Does that answer? Right. Right. Well, yeah, I think that's right. I think that some of the problems we have are with judges that don't understand how much money means to people when it's not the money they're used to having come out of a big law firm. And so I think that that's a real issue. And, you know, it spills over into attorney fee applications. And there are two parts to that. One is the sense that if you're a public interest lawyer, you're just not worth it. You know, I mean, if you're at a big law firm, you're clearly worth the money, but if you're at a public interest law firm of the same level of experience, you're not worth it. And the other thing is that they look to the value of the claim. Well, you brought this case and you spent $20,000 of your time on it, but you only got your client $7,000. Well, hey, it's a low-wage client. Of course, it's only $7,000, but that's a huge amount to our client, and it did take us as much work to get that as it would have gotten to take, you know, a person that had a damage award of $45,000. So this is inherent undervaluation of the worth of these kinds of cases, which, by the way, is why private attorneys don't take them. Because I admire a lot the private plaintiffs bar, and they're very close to us. They help us with our workers' rights clinics, but they can't afford to take cases of low-wage workers because they're on a contingent fee, and there's just not enough money for them to take. By the way, one other thing, did I mention that we never get pro bono help? I just wanted to mention this one other challenge that we face, because law firms now assert a positional conflict to employment law. And so, whereas in other areas you can get co-counsel, that kind of helps you with staff and with resources and with paralegals and with funding of expert witnesses and stuff, law firms won't come near any kind of employment case, because anything that might arise out of it could adversely affect the interests of any of their clients. So it puts us really out there on our own doing this work, without any help at all.
But you still get them help fund.
But we do it. We do it. We do it.
One of the themes that you sounded pretty heavily tonight was the question of confidentiality
Right.
relating to settlements.
Right.
It's worthy of a lot more thought and discussion. On one hand, it promotes settlements, and you've indicated that many of the cases you bring should settle, and
Right.
it's to the benefit of the clients rather than going through long litigation. But on the other hand, it closes transparency and
Right.
blocks it. And if you think about this for a moment, sealing of records has become an issue that courts have taken up, and there are now local rules in some districts that preclude or place a heavy burden on the sealing of records.
Right.
And I wonder whether your organization has given enough thought to the whole question of confidentiality, which is simply a contract between the parties.
Right.
Right? And whether you've thought of systemic ways to attack this issue of transparency.
You know, I would really love what thoughts you have about that. What happens to us often is settlements will be created, and it's an all or nothing thing. I mean, a defendant will say, we will settle this case only if you agree to these confidentiality provisions, period. And then we go to the client and we say, this is what we can offer you. And the client, I mean, we have not had a client that said, I won't settle because I insist on no confidentiality. So that we're sort of stuck on that. But if you have thoughts about ways to open that up, I would love that. That would be really great.
So, my home state is Wisconsin, and we've been
Aye.
with workers' rights in the news
Right.
recently.
Right.
So I was wondering just to get a little bit of your take on that, as to, and I mean, for a little bit of background, people who may not be following it, our governor and one side of our legislature, while the other side was in a different state, passed a law that took away a lot of collective bargaining rights. I was just wondering what you think is a good sort of national response to that, and whether this is really like a good opportunity to discuss workers' rights and how we should move forward with that.
Yeah, I definitely agree with that. I'm troubled by what occurred in Wisconsin, because a lot of the workers that we represent might have been in unions 20 years ago and aren't anymore, and are so thrust out on their own, and in situations where they don't have the backup of unions. So I think what the governor of Wisconsin did was terrible, but very politically motivated and supported by the Koch brothers. I mean, there's a whole other story behind that, right? I think. But it doesn't look like anyone's willing to take it on. I mean, the president has been remarkably silent on this particular issue. But the issue of public employees and the conflation with budget problems, I mean, it seems to be a good cover for it. And it's probably going to happen in other states as well, or at least efforts to make that happen in other states as well. I think it's terrible. But in this country, our organization doesn't do union stuff. We can't do it all. And the three things we don't do is workers' comp, don't do that, there's a specialty bar for that. We don't do ERISA, because there's a specialty bar for that. And also people who have ERISA rights are not poor, because they work at places that can afford them those benefits. And we don't represent unions because there's a union bar. And in fact, interestingly, for many years in my organization, suing unions was a tough and hot issue, and there was a lot of disagreement about whether it was okay to sue unions. For race discrimination, for gender discrimination, because the politics at the time were such that people would say no. This is not, you have to just let unions be. Well, we didn't, yeah, but I think it's terrible what's going on. Poor you, coming from Wisconsin.
One last question. Yes.
You spoke again and again about the lack of support and a lot of times isolation of low-wage workers. How did your organization fill those gaps? I mean, other than legal help, how do you
You know, the answer to that is that we have very personal relationships. I mean, you take on the role of social worker, you take on the role of family member. I mean, the thing that I came to appreciate over the years is that our clients are very vulnerable economically, but also very vulnerable as people. People that have been subjected to oppression and discrimination and maltreatment are fragile, and they come to us fragile, and then asking them to go through litigation where they're really beaten up. I mean, it's a very, very difficult and painful experience for them, requires a lot on the part of the staff to give them emotional support. So it's just not representing a client, it's kind of holding up a whole person during the process. And part of that is that we very carefully evaluate the emotional and psychological strength of our clients to withstand the stresses and tensions of litigation. Because, you know, there's some people that simply can't do it. They just can't. And so I think it's tough. And also we'll try to connect them to community groups that are interested in the same issues that they're concerned about.
Joan.
Oh. Thank you. Really, thank you so much. This has been an incredible treat for me. I really, really thank you.
Never had a speaker thank us, and this is the first. Anyway, thank you. That was absolutely marvelous. I want to invite everybody downstairs to the Great Hall, where you'll have an opportunity to follow up and speak with our speaker about her incredible career. So welcome to you all, and let's all go down to the Great Hall and continue the conversation. Thank you.